Hello, this is Michael Martin, President of ECFA. It's my privilege to welcome you to today's ECFA webinar on the Supreme Court Redefines Discrimination Law, Practical Responses for Religious Employers. This is such a critical and timely topic with not only legal and HR issues, but also important ministry implications. Because of that, we're pleased to have with us today two very good friends of ECFA who are leading experts to walk us through these issues. Our special guest presenters today are attorneys Stu Lark and Bill Wright from Sherman and Howard. For more than 20 years, Stu Lark has focused on helping nonprofit clients navigate complex matters related to their distinct operational and legal challenges. Stu is also one of the leading facilitators of the Ministry In-House Counsel Roundtable, which is a tremendous resource and support to ministry in-house counsel across the country. And by the way, Stu didn't pay me to say that. For nearly 25 years, Bill Wright has advised employers on all employee relations matters. Bill also holds a PhD in ethics and is a sought-after speaker and thought leader on employee relations as well as corporate and human resources ethics. I'm looking forward to hearing their insights on the recent Supreme Court decisions regarding employment and discrimination matters and practical steps that ministry organizations can take to strengthen their legal rights. Well, what's a good legal webinar without a legal disclaimer? I should note that while Stu, Bill, and I are attorneys, the material on today's webinar is provided for general information purposes only and is not a substitute for legal advice particular to your situation. No recipients of this information should act or refrain from acting solely on the basis of this webinar without seeking professional legal counsel. Well, before we continue much further, let me open our time in a quick word of prayer. Well, Heavenly Father, we just thank you so much for this day. We thank you for this opportunity that we have to get to come together and focus on these important issues, not only from a legal and an HR perspective, but also a ministry perspective, which is so important to the critical missions that you've called us to. Lord, I just pray for Stu and for Bill as they share today, that your Holy Spirit would speak through them. And I also just pray for each person who's listening, Lord. Thank you for all the ministries who are represented. We just pray that this time together would bring you glory and honor. In Jesus' name, amen. Well, just a couple of other quick housekeeping items, and then we'll get right to the topic of the hour. A copy of today's PowerPoint slides should be in your email inbox from this morning. If you didn't receive them, they can be found on your screen in the right-hand corner of the GoToWebinar controls under the handouts icon. Throughout the webinar, please email your questions to webinar@ecfa.org. Also, open your Twitter account and tweet your questions and takeaways for today's webinar to the hashtag AskECFA. We'll be reserving time at the end of the hour to cover as many questions as possible. Each person desiring continuing education credit must be separately logged into the webinar today and answer all polling questions when they briefly appear on the screen, like the one you see now. In order to receive credit for attending the webinar today, please respond to these questions. If you have technical difficulties, please email your responses to the poll to webinar@ecfa.org. Even though the polling questions are only required for continuing education credit, we'll appreciate everyone's participation. Well, with those important announcements behind us, and without further ado, I'll now turn today's presentation over to our distinguished guest presenters, Stu Lark and Bill Wright.
Thank you, Michael. Greetings, everyone. This is Stu Lark, and as Michael said, today we're going to be talking about sexual liberty and religious liberty. And to apply a line from Charles Dickens to our topic today, I think it could be said that these are the best of times and the worst of times. Laws protecting both sexual and religious liberty are arguably better than ever. But at the same time, many proponents in one or the other of these areas perceive threats as being greater than ever as well, and they may well be right. In addition, Some assert that the victories that have been achieved for religious liberty, one of which we'll talk about today, have come at a cost, the cost being a lost voice for Christians in our culture. And we'll return to that notion at the end of the presentation. But first, we are going to discuss key points from the Supreme Court's two most recent cases, one advancing sexual liberty and the other advancing religious liberty. And then we are going to present practical responses for your organizations, both from an HR perspective and from an organizational leadership perspective. And with that, my partner, Bill Wright, is going to get us started.
Thanks very much, Stu. This is Bill Wright, and I wanted to start by saying how very pleased I am to be able to share the virtual stage here with my colleague, Stu Lark. Stu and I have known each other for a lot of years, but he's really, over the last 25 years, become such a leader in the country on these constitutional issues that it's a real pleasure to be able to put my name next to his on this kind of presentation. But with that in mind, I encourage you all to think of as many difficult questions as you can possibly ask Stuart and put them all in the question and answer phase so that we can try to stump Stu. My first part here is to talk about the Bostock decision from the Supreme Court this year. And many of you may be familiar with the Bostock decision as the one that famously expanded Title VII of the Civil Rights Act of 1964 so that the word sex now includes both sexual orientation and gender identity. So let me start by mentioning a couple of things about Title VII. Title VII of the Civil Rights Act of 1964 is the federal statute that prohibits discrimination in employment actions because of race, color, national origin, sex, and religion. There are, of course, other statutes. There's the Disability Act that prohibits discrimination on the basis of disability and requires reasonable accommodations. One of the cases that Stu's going to talk about is a case that came up under the Americans with Disabilities Act. There's the Age Discrimination Act, which prohibits discrimination against people who are 40 years of age and older. And I think the other case that Stu's going to talk about came up under the Age Act. But the Bostock decision in particular is a Title VII case. And it's actually three cases, which I'll describe here in a moment, all around the ideas of what it means to discriminate against someone because of sex, and whether sex includes sexual orientation and gender identity. Now, Title VII and all these other statutes also, incidentally, prohibit harassment and retaliation. I'm not sure how many organizations we have. It looks like we've got 620 participants at the moment, but the Title VII really only applies to employers of 15 or more employees. That's not, however, to say that smaller employers are out of the woods, because almost every state, all but three, I believe, have a state statute that also prohibits sex discrimination, sometimes explicitly prohibits discrimination on the basis of sexual orientation and gender identity. And many of those statutes go down to include smaller employers as well. So even if you're a smaller employer and you don't have 15 employees, you'll still want to pay attention to what the Supreme Court says about the religious liberty rights that Stu's going to mention. Incidentally, the statutes also apply to anyone who acts as an agent of an employer. So if, for example, you outsourced your hiring to a leasing company or to somebody who's doing the recruiting for you, you could find yourself liable, and they could be liable for discrimination that they perform on your behalf or that you adopt from them. And so merely outsourcing doesn't help. There is, however, a general consensus that there's no individual liability under Title VII, by which I mean there's no way that a manager, for example, can get sued under Title VII. Only the employing organization can be sued. Okay. And importantly, there is an express provision of Title VII that permits religious employers to employ those who are of the same religion on activities involved with their mission. And so there is an express provision in Title VII that provides a permission for religious employers to employ members of their own religion. Sometimes we might slip and go legalistic on you and refer to this as the 702 provision. So if for some reason Stu or I start talking about 702 in the questions and answers, that's what we're talking about. The provision that permits religious employers to employ those who are of the same faith. Okay, so let's slip on to the next slide and let's talk about these three cases that were consolidated into the Bostock decision. One of them is Zarda. Zarda was a skydiving instructor, and in order to reassure a female client, this is the kind of skydiving operation where you get strapped to the skydiver, and then he jumps out of a plane carrying you so that he pulls the parachute and you have a better chance of surviving. And in order to reassure a client who was a woman, he announced to his client that he was gay. This was apparently the first time that his employer had learned that he was gay, and he was fired a few days later. The Harris Funeral Home case, right, that's the transgender case out of these three. And there's a funeral director named Stevens who was hired as a man and one day announced that henceforth he was going to present as a woman. And the employer in the organization, Mr. Harris, said, well, this isn't going to work out, and fired him. And then there's the Bostock case, which is a public employee case. He's a county employee, and he'd been working for 10 years for the county and then joined a gay recreational softball league and created a whole bunch of public outcry. People were complaining that their representative in the government was going to be playing in this recreational sports team, and so the county fired him. Now, none of these cases has yet gone to trial, right? Because they're all ones that were decided on summary judgment or appealed from summary judgment, and so we don't really have all the facts that we might want in all these cases. We have some of the facts, but the main thing that goes up to the Supreme Court on these issues is the very legal principle about whether there is liability under Title VII at all if the person is claiming that they were discriminated against on the basis of their sexual orientation, or if they're claiming they were discriminated against on the basis of their gender identity. Okay, so let's slip down to the next slide here and let me describe how the Bostock decision worked. The Bostock decision took advantage of two provisions in Title VII. Title VII was amended in 1991. Before the amendment, it read, you will not discriminate on the basis of sex or race or religion or national origin or color. Right? And in 1991, they added another provision that said it's sufficient to show discrimination under Title VII if you can show that the employment action at issue was motivated, at least in part, by the employee's sex, race, religion, color, national origin. So there's two different kinds of liability provisions in Title VII. One is just that you are liable for discrimination if the employment action at issue would not have occurred if the employee were not of that particular sex. The other provision is the motivational factor provision. The person who made the employment decision was motivated, at least in part, by the employee's sex. And the thing that you need to pay attention to in the Bostock decision in order to understand the justice's reasoning is that the court relied exclusively on the first of these two provisions, relied exclusively on the notion that employment action would not have occurred if the employee were not of a particular sex. And so there isn't really any discussion in the case at all about the particular motivations of the supervisors. Nothing about what their intention was or what they believed or what the form of their reasoning took. It's all about the nature of the concept of sex. So slipping to the next slide then, I got a couple of quotes here from Justice Gorsuch, who wrote the opinion. And the key one is the first. According to Justice Gorsuch, it is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. This and keep in mind, this isn't about what individual people are thinking. It's about the fact that sexual identity, sexual orientation, and gender identity are tied up with the concept of sex. He does sometimes say to discriminate on these grounds requires an employer to intentionally treat individual employees differently because of their sex. But when he does that, and he cites a case when he does that, it's clear that what he means there is intentionally the way that intentionality is used in many other statutes, to mean just knowingly and voluntarily, not the kind of motivational analysis that goes into the motivational factor test. So still not talking about the motivation of the individual supervisors. Okay, so then the next slide. A couple of things that were clearly not at issue. Okay. What is not at issue in Bostock is the religious employer exemption. That's what I described as the 702 exemption, right? The exemption that says that employers, religious organizations may employ persons of their own religion. There's some sense in which the funeral home was a religious organization, but that issue did not go to the Supreme Court. The Supreme Court did nothing except promise that maybe there would be cases in the future where those sorts of things might be addressed. And so we don't know, as a consequence of Bostock, how the Supreme Court is going to rule on the religious employer exemption in Title VII. Okay. And we don't know what they're going to say when a religious employer says to them, listen, I fire that person not because of their particular sex, but because their conduct was in violation of the religious beliefs that we require all our employees to share. So that's the Bostock decision. Let me turn it over to Stu to talk about the other religious liberty issue.
All right, thanks, Bill. And so next slide, the 702 religious employer exemption that Bill just finished on would be one avenue of, let's say, defense that a religious employer would want to consider if there was some question about whether there was unlawful discrimination based on sexual orientation or gender identity under this new interpretation from Bostock. Another avenue to consider would be asserting a constitutional doctrine, which has in the past been referred to as the ministerial exception. And in fact, about 7, 8, 9 years ago, the Supreme Court had its first case where it considered this doctrine of the ministerial exception, and it ruled unanimously that civil rights laws, such as Title VII and the other ones Bill mentioned and others, do not apply in that case to a fourth grade math teacher because she was a commissioned minister and she was performing important religious functions for a church school. And as I noted, this was actually a unanimous decision, and it built on a whole lot of cases in lower courts that had been developing and applying this ministerial exception doctrine for many years. But this was the first time it had reached the Supreme Court. And but what came out of that decision was a question about well, where do we go from here? The decision didn't kind of totally articulate all the parameters of who might qualify for this exception, and so one of the natural questions that came out, well, what about teachers who are not quote unquote ministers? They haven't been commissioned in some way or licensed or ordained in some sense, and two cases made their way to the Supreme Court this term. One involved a teacher who was terminated due to age, at least that's the allegation, and the other one a teacher who was terminated for requesting leave to get cancer treatment, and they were both at Catholic schools, and neither of them were any kind of licensed or commissioned or ordained minister. So what did the court do with that? Well, before we get to that, let's go to the next slide. We, as we have from time to time, we filed what's called an amicus brief, a friend of the court brief, on behalf of a wide range of religious employers to make some points before the Supreme Court in this case. We were grateful that ECFA was one of the religious employers that joined that brief. And we made 3 arguments that we wanted to bring to the attention of the court in the case that we thought would be important for religious employers going forward. One of them was that we thought that the so-called ministerial exception should extend to any employee, regardless of title, who performs functions that define, exercise, or express the religious character or mission of their employers. And generally what our arguments there were, well, any employee that's engaged in activities that are, religious exercise or religious expression, they should be subject to this kind of doctrine in the same way that ministers are. We also argued that the court should avoid a particular formulation of important religious functions because we thought that would lead down rabbit trails when it was applied. And lastly, we argued that being a faith community is itself religious exercise and expression, that it is part of often anyway, it can be part of the organization's mission. And in the next slide, we wanted to kind of bring out the faith community angle to broaden the focus from just so-called religious activities and kind of whether the employee is sort of doing things that seem religious, to focus also on what might be called the integrity or the expression or exercise of the faith community itself. And we built on a quote from a famous case, 1987, where Justice Brennan wrote an opinion that has been long copied, and it really kind of derived this point home. For many individuals, religious activity drives meaning, in large measure from participation in a larger religious community. It's the community element of it that's important. And so we kind of we wanted to build in that argument. And we'll kind of see a little bit even more why later. But anyway, move on to the next slide. The court did, in fact, expand and kind of jettison the idea that you have to have a minister title in its decision. It ruled in favor of the schools and employers. And generally, its formulation of the test now is something like an employee who plays a vital part in carrying out the mission of the religious employer. Any employee who fits that parameter would be not protected by civil rights law. The court did not use the important religious functions wording as we had advocated that it not use, so that was good. And this formulation of employees who play a vital part in carrying out the mission of the employer, we think it's consistent with what we were arguing for, and it is also consistent with the mission, including just being a faith community. And then lastly, what the court did was it gave an open invitation to our religious employers to define which of its roles are a vital part. And that's on the next slide. There's a quote that I think is really worth highlighting. So the court said, in a country with the religious diversity of the United States, judges cannot be expected to have a complete understanding and appreciation of the role played by every person who performs a particular function in every religious tradition. And this is largely, courts have gone in this direction in many different ways in recent years. They just don't want to get into the weeds on this stuff. And so he says here, a religious institution's explanation of the role of such employees in the life of the religion in question is important. And that's an invitation to all of you, to us, to really work hard at defining our roles so that we are in a position to assert whatever protections we can under this doctrine and other ones. And so that's going to serve as our segue, summarizing these two cases, our segue to practical responses. And as I said, we're going to address these at both from kind of an HR perspective and then a little more from an organizational perspective. So I'm going to throw it back to Bill to pick up on the HR side.
Great, thanks very much, Stu. So what I mostly do with my time is confer with human resources personnel in organizations, and sometimes act as the human resources personnel when there aren't in-house HR personnel, and provide a sounding board and best practices for HR personnel. So I wanted to start by talking very broadly and generally about concerns that an organization might well have if faced with this kind of employee dispute. And so the first thing to understand is that employment litigation starts with an action by a disgruntled employee, usually. And employee might bring an administrative charge by filing with the EEOC or by filing with the local Fair Employment Practices Agency, the Human Rights Commission, or whatever the state commission or even city commission might be called. Or it might start directly with a complaint going into court if there's some action that does not require previous action by an administrative agency. If they're suing on a tort or a contract or a statutory violation, they can just go straight to court. And so the court action or the dispute begins with the employee's action, and the employer doesn't get a chance to assert the mission exception that Stuart was talking about, or the religious employer's exemption in Title VII itself, right, until after the matter has started. And so even in a court where the religious exemption is going to apply and where you're going to succeed ultimately on winning, you don't get to head off the lawsuit that way very often. Often you end up dragged into court anyway, and you end up having to spend money on legal fees to put together the defense, to file a document that responds to the charge or that answers the complaint. The court might not rule right out of the box with regard to whether the exception or the exemption applies, and so you might find yourself funding your lawyers through a lot of litigation, even if you're eventually going to win without even going to trial. You might have to pay through the discovery phase, which can take easily 6 months and often a couple of years, with regard to exchanging written questions and exchanging documents and taking depositions. All through that time, you'll be paying your attorneys, even if you win. You might end up having to brief summary judgment in order to get the court to recognize the legal principle that is expressed in the exemption or in the exception. And in a case where the court doesn't necessarily recognize the religious employer's organizational rights, you might find yourself having to go through trial and then funding an appeal. Look at those cases Stuart was just talking about. They went all the way to the Supreme Court, and I am almost positive that the lawyers were being paid. So these issues are, on a practical sense, very important for religious organizations, because even if you have an absolute winning lawsuit, you are going to end up out of pocket just defending it. So I want to talk more practically about how to put yourself in the best position to avoid it in the first place, and then, of course, to win it in the long run. So the next slide then, just practically speaking, in my experience in 25 years of defending these lawsuits, plaintiffs begin these lawsuits because, sometimes because they've suffered an actual injury, right? Their emotional health has been damaged. Certainly their economic situation has been damaged. Sometimes they do it just out of outrage. Sometimes they do it for a need for vindication, especially when they have families and they need to go home and explain why it is that they are not working anymore. And sometimes just because they're out of money and they figure this is a way to get a settlement and to try to make a little bit of money to tide them over. And so generally speaking, the best way to avoid getting into these kinds of disputes is to have really solid human resources practice. And so for those of you who have a human resources group, you want to value that group and give them the leeway to make their best professional judgments on your behalf, because they're the first line of defense. They're the ones who are going to keep the motivation for filing a lawsuit down. Okay. How do they do that? Well, first with transparency with regard to expectations and evaluations. So you want to be very upfront with people about what it is the organization expects. Okay. You want to evaluate them on the basis of those expectations. So you need to pay some attention to the job descriptions, the mission statement of the organization, how those things are rolled out to the employees, how the evaluations that you might use on an annual basis, for example, reinforce those expectations. And secondly, you can rely on your HR people to address under your organizational policy any actual injury that comes up. So if someone feels that they've been treated unfairly, you're going to have policies in place that direct them to take that issue to the HR people or whoever is acting as if they were in HR. And you're going to expect the HR person to be able to deliver an effective solution for the problems that that employee is facing before it turns into such a sense of outrage that they just can't help themselves but sue you. And then finally, also, you're going to want to be able to resolve interpersonal disagreements in accordance with policy, whether you're following Matthew or some other way. You're going to want your HR people or people that they train and delegate to help the employees get over their outrage and their need for winning a dispute in order to avoid ending up in litigation in the long run. Okay, so down in the next slide then, in particular, all your organizations are going to want to consistently apply your religious requirements for your employees. You're going to apply them regardless of sex, race, color, national origin, age, disability, genetic information, veteran status, all the other statuses. This isn't to say that you are subject to these laws. This is just good business. This is sensible stewardship of the organization. You're going to have your policies and you're going to apply them consistently. There's a note here that says it mitigates the pretext argument. That's maybe a little technical. In these kinds of Title VII suits, typically what happens is the employee has to present what is called a prima facie case in order to get into the court door. Mostly just means they have to allege that their race or color or national origin is at issue and they suffered an employment action and there's some connection between the two. And the function of that prima facie case is just to throw it back on the employer to state what the real reason was. The plaintiff wasn't in the room when the HR people and the managers decided to fire someone, and so the plaintiff doesn't really know what happened. So the prima facie case is a way of kicking the court case back into the lap of the employer, so the employer has to say what happened. And the employer is typically going to say something like, well, we applied our policy with regard to the religious community. And then in your typical Title VII case, the plaintiff has to show that, no, you're lying about that rationale. It wasn't really an application of your religious community policy. It wasn't really an application of your attendance policy. It wasn't whatever it is that the employer says was the reason. And they do that by pointing out inconsistencies. They do that by pointing out somebody else who did the same thing and didn't get fired. So it's important to have consistency with regard to the application of your various policies so that you don't fall prey to an easy counterexample in the court case. That's what that mitigates pretext argument means. My second important tip here is to avoid rudeness, innuendo, jokes, sneers, cartoons, and abuse, really on any basis. There's no good reason to have your workplace sort of place where people post cartoons pointed at each other or scrawl invidious sneers on bathroom walls and that sort of thing. You don't want to have that kind of employee place. You don't have a place where they hang nooses. You don't have a place where they hang pornography. You don't have a place where people just naturally have their feelings hurt all the time. And that's, again, just basic HR practice. And so it's important, I think, to avoid that kind of outrage that fuels employment disputes. You want to have a Christian-seeming organization. Okay? And that includes the workplace. And then, more in sort of finer detail, if we go on to the next slide here, you do want to make sure that you've got some paperwork in place. You want, for example, to have your job descriptions describe the vital part that the person who does that job fills in the mission and faith community. It's just part of describing the role so that you've got it clearly. You want to be able to show, if you're in a court, right, you want to be able to show that you discussed that with the employee at the time that they were hired, or at least at the time when the job description was revised. It's going to be very explicit about what their role is, and you want the employee to acknowledge their receipt of it, not so much because it becomes less important to you if they refuse, as to make it easier for you to show, yeah, we in fact were transparent, we were very open about this, they knew that we were a religious organization, they knew our expectations. You do that by being able to show that the employee acknowledged the job description. And then, of course, you want to align the job descriptions and your employment policies with board level policies. You don't want to have two different organizational set of expectations necessarily. And then the performance evaluations. You're going to evaluate people on the basis of the job description, which includes the vital part that they are playing in the mission. And my caution to you is not to allow your desire to have the organization run efficiently like a corporation should obscure the essential mission-related function. These are religious organizations, and we have a religious mission, and we have people who fulfill the religious mission, including playing roles in chapel or in resolving disputes or in prayer that you would not find in a typical corporate job description. Do not let your drive for efficiency scrape away those various religious elements that really make the organization what it is. Okay. Now, let me turn it over to Stu for some other insights with regard to senior leadership perspectives.
Okay, thanks, Bill. So one of the things that comes up with respect to this doctrine that we formerly called the ministerial exception was, and I think we're one slide ahead here, was how far do we, oh, sorry, no, we're right. You're right, sorry. How far do we go? How far can we take this? If the positions go beyond minister, like could they actually extend to all positions within a religious employer? And I don't have an answer to that question right now. I don't think anyone could give a definitive answer, but I do have some thoughts about how we could best position ourselves to be in a position to assert the doctrine, the exception to any employee. And part of that turns on understanding ourselves as a faith community. And many organizations already do this, but maybe not as fully or completely as they could in light of the recent case. So my first point here is determine whether and how nurturing a faith community is part of your mission. And maybe that would extend to kind of reconceiving your mission, whether it's your formal mission statement or just more something you sort of understand internally. So an organization's mission might be to serve the needy or educate kids. And maybe it's worth saying, well, actually our mission is to create a community that serves the needy or educates kids. So for instance, my church, my home church here in Colorado, has a mission that says we're light and life for the community. Well, that's great and true, but it sort of implies, it doesn't bear out, we are actually a faith community. We're a worshiping community that does those things. And so we want to maybe be more clear somewhere that that's who we are. And then we can identify the employees who play a vital part in nurturing our community. And I've thrown in a verse here that I think most of us would be generally familiar with. I mean, we do understand ourselves to be part of the body of Christ, and we view all those who are members of the body as being vital parts, indispensable to sustaining us as a body. If we can get that into our documents, then we are, of course, in a much better position to assert that any of our employees, all of them, are playing a vital part in our community. Okay, so that's one thing. Next slide then. You can determine that, the extent to your community, and then you should document that. Have a policy that describes your community, your mission standards, and describes them as an exercise and expression of your beliefs. Some organizations may need to go through a little time to review, clarify what their beliefs actually are pertaining to sexuality and marriage in particular. I found that some organizations, aren't fully clear as to what their actual beliefs are, but so maybe you need to do that. But then it's the more difficult thing for a lot of organizations is what does it mean for our employees, for our volunteers, for our guests, for those who, to use another perspective, who are members in various ways of our community? What standards do we have for them relative to those beliefs? And it's important to get those standards clear and to connect them to the exercise and expression of your beliefs. And I would say you want to start with standards that revolve around shared beliefs, and then progress perhaps to conduct standards, living in accordance with those beliefs. And you can affirmatively identify in that context those who you think play a vital part in your mission, and even if the mission is part of your community. And then more generally, you might want to have standards as well for the activities you conduct and for the uses of your facilities. Okay, and then on to the next slide. There are a whole range of other additional considerations that organizations should take time at least to build on a little bit if they can. So some organizations are recognized as churches. That concept has grown and broadened in recent years, so maybe that's something your organization should consider. The concept of being a minister, maybe you can expand on that some, because it's still preferable, all things being equal, to be in a minister position as not in terms of legal protections. You might reevaluate qualifying services for the housing allowance, the exclusion from tax for payments paid for housing. It might be broader than you think. I think it's helpful to document how your activities further your mission, particularly if they're sort of not conventionally understood to be religious activities. And to be clear as to when you're engaged in commercial activities like sales of goods or services, to be clear about how you do that differently than a commercial operation in ways that connect to your mission. I think, and this is building a little bit off of Bill's comments, it's preferable to be clear about where you're coming from, and so that prospective guests, customers, aren't lured into the organization thinking you're one kind of organization, and then once they're committed, they have buy-in, they think they're part of it, to find out that in fact your views on things like sexuality and marriage are not what they thought they were, and those kind of situations are often ones that result in litigation just because of the seeming indignity that the people feel. Okay, and then last slide on this piece. I just want to, I mentioned at the beginning that there's a line of thinking, and who knows whether it's totally true or kind of valid, but that in gaining the religious liberty protections that we have, and I very much say we have great law protecting religious liberty, that maybe as a Christian community we've lost some of our voice. And so my last practical response is to find your voice, and to find it in a way, hopefully with God's guidance, that we can be more effective in articulating our voice, both in the legal realm, so that might include negotiating contracts, supporting legislation, engaged in litigation, as well as more generally in sort of presenting the gospel to our culture. And I have big bold points here because this is going to be a big paradigm shift, especially for us lawyers who live in this world. But I would say, do not call this doctrine that we used to call the ministerial exception, do not call it that anymore. The doctrine doesn't turn on being a minister, and it can create a lot of confusion in implementation within your organization if you're sort of fixated on calling it the ministerial exception. So that's a practical thing there. With respect to communicating the gospel, there's a broader thing here I want to just give us a little bit of overview to, because I think it's important, and a lot of us feel like may feel like this culture is really, so much against us that kind of expressing our views, even on sexuality and marriage, is just perilous. And so I just want to point out, for instance, that the liberal majority and the Obergefell's the decision a few years ago that legalized same-sex marriage nationwide, the liberal majority in that case, went out of its way to say that we can continue to advocate for our beliefs about human sexuality and marriage. And then in the next slide, it's even worth kind of comparing what the court said about sex, sexual orientation, et cetera, in that case with the case from many, many years ago, 50 years ago, that held that you couldn't ban interracial marriage. In that case, Loving versus Virginia, the court considered racism as appropriately as being odious to a free people. But in the same-sex marriage case, the court, again, the liberal majority, said that beliefs about, that traditional beliefs that can be held by decent and honorable people, and it can be held in good faith by reasonable and sincere people, decent and honorable premises, I would say. So there's clearly a sense that, at least from the Supreme Court, that it's okay to believe what we believe. And I just want to kind of encourage us in that regard, to the extent that we feel like, any sort of any view about sexuality that isn't sort of totally in line with current cultural norms is considered to be, out of line and racist. And in fact, in the Masterpiece Cake Shop case from a couple of years ago, the court held that the Civil Rights Commission, the Colorado Civil Rights Commission, violated the religious exercise rights of Jack Phillips, who owns the cake shop, by disparaging his beliefs about human sexuality and marriage. And so he won that case, as you may recall. And the court ended its decision by saying that the outcome of cases like this, and this was a case that kind of pitted or was going to pit sexual liberty against religious liberty, must await further elaboration in the courts in the context of recognizing that these disputes must be solved with tolerance, and then these 2 points, without undue disrespect to sincere religious beliefs and without subjecting gay persons to indignities. And so that's a framework that we might want to think about in terms of how we communicate the gospel. And I could build on that with the next slide, just by kind of going back to the Bible and pulling out 1 Peter 3:14, which says, as many of you would know this, that if we suffer for what is right, we are blessed. We are not frightened. We are to revere Christ as Lord in our hearts, be prepared to give an answer to everyone asks, to give the reason for the hope that you have, and do this with gentleness and respect. And of course, that's Jack Phillips, if anyone would know, a sort of icon of gentleness and respect. And in fact, that may be why he won the case. And so I would say that this is not just a biblical command, it's also an effective litigation strategy. And we can follow Jack's example because, as the verse says, we are blessed. We're not afraid. Even in the worst of times, if that's what these are, we have hope. And actually, this brings me to my last practical response, which I've characterized as a challenge to all of us. First Peter says that we must be ready to explain the reason for our hope, which is the gospel. And here, as we can see, another way to say it is freedom from the law of sin and death. And my question is, can we learn from these cases how we might do that more effectively? Our culture values notions of dignity, identity, liberty, and choices. And I would say there are shared starting points in these notions, since as Christians, we believe the gospel fulfills these notions. We affirm that our ability to make choices is part of being created in God's image. And our free will does reflect an element of dignity, but it is incomplete. In the last slide, a few years ago, I visited a cathedral in Barcelona, and looming over the main entrance is this statue of Peter having denied Jesus, with Judas in the background selling Jesus to the Pharisees. It's a riveting display, and it shows our choices, I think, our choices draining us of our dignity. And the fact is, our notions of dignity simply cannot bear the weight of our choices. But entering the cathedral brings you into intimate, glorious color, all focused on the cross. And it becomes clear that our dignity as sinners does indeed flow from the cross. And this, I think, is where we must strive to focus the conversation, to use our voice. Because far more important than our fleeting religious or sexual liberties, or the dignity of our choices, is the enduring good news that we have been freed from the law of sin and death, and that all is well. So thank you. We're anxious to take questions.
All right. Well, hey, excellent job, Stu and Bill, walking us through that material. Well said. And as you can imagine, with a topic like this, Stu, you said you were anxious to get some questions. Well, we have some questions for you. So let's see how many we can squeeze in rapid fire here. And I'll just throw these out, and then I'll let either one or the two of you address them. The first one relates to, we had a couple questions that came in. I know we talked a lot about federal law, but also state law. So general question is, please address whether the laws of a particular state may be more restrictive on the ability to make hiring decisions on the basis of religious affiliation. So that's the first question that came in.
All right, I'll take a shot at that. And yes, the answer is that a law may be more restrictive at a state level, or even sometimes at local jurisdictional levels. Fortunately, I guess, the body of cases that I was discussing, what I'm saying we should not call the ministerial exception, it is a federal constitutional right, which would apply even to state or local law. So that's a one element of our defense that would be relevant, even if there are local laws that are less hospitable or less accommodating of religious exercise. Bill, anything more specific in that regard?
No, I think that's the main point to make, is to the extent that we can argue in any particular dispute that the Constitution, the U.S. Constitution, is really the overall governing law of the issue. The formerly known as ministerial exception is key to our defense.
All right. Well, next up, and I'll work here on reforming my vocabulary as well. But the questioner came in, does the ministerial exception, religious community policy, I'll insert there, does it apply across other areas of employment law, such as minimum wage and overtime and other areas?
Yeah, so there have certainly been a number of federal cases that have applied the exception formerly known as ministerial to wage and hour laws, federal wage and hour laws in particular, including the exemptions from overtime pay. At the state level, it's sort of catch as catch can. Some states have addressed it and some states haven't. And the places where they haven't addressed it, we are still looking for the appropriate case to bring that up and try to get an appropriate ruling. But certainly with regard to wages, to the extent that we've got mission-based employees who are accepting less than minimum wage to be a part of the mission, we've got a very good case to apply the constitutional principles to those cases.
Good. Now that's helpful clarity. Then we had a couple of questions that came in related to the PPP. So another very relevant, timely topic, and let's talk about the intersection there. So the question that came in is, if Christian schools or other ministries have outstanding PPP loans, are they subject to Title IX requirements, troublesome since Bostock and the recent decision in the Grimm case, or do the SBA rules protect Christian schools? So I'll throw that question your way.
Well, I'll take a first stab at it.
Stu, I assume that's for you.
Yeah, I'll try.
I think you said all the tough ones go to Stu.
Yeah, there's not going to be a definitive answer here. One of the sort of additional elements that comes into play with the PPP loan and similar kinds of contracts or agreements is that the borrower has agreed by contract to be subject to certain conditions. So this isn't just a general law like Title VII that applies to someone just because they're an employer. It's a contractual obligation that's been taken on by the borrower. And then the question comes, well, what exactly is the contractual obligation? And does the government even have the authority to impose such a contractual obligation in the context of the PPP loan? And I would say that in the context of these loans, nobody knows. I'm sorry to say, maybe either of the answers. To the extent it was feasible at the time, we encouraged borrowers to add maybe a statement in their application saying, I'm not incurring any obligations under this agreement that don't otherwise apply to me under general law. And I think that's very much where the Trump administration wanted to land anyway, with the PPP loan conditions. And everyone knows that they are operating under, sort of extreme emergency situations. So I would not, as a sort of starting point, be overly concerned that somehow they're going to use the agreements made in PPP loans as a way of sticking it to religious organization borrowers. But the general principle that that religious employers should be aware of contract conditions in any kind of a contract they sign still applies more generally, even outside of PPP loans. That's one of the points that I just went over real quickly in the Find Your Voice section of the slides, that negotiating contract conditions is something that all of us should be aware of and engaged in.
Good. No, that's a great discussion. I know that's a very current topic, so not a lot of precedent there, but that's good perspective. Next question is, as a faith-based parachurch organization who does not have church or religious order status, question is, are we more vulnerable to what they're calling the ministerial exception challenges? Are there other particular mitigating measures that we can or should take in their case as being a non-church classified organization? So how does church status play into all of this conversation?
Yes, okay. Well, church status, I think as an optics, helps support the assertion of I'll call it the religious mission. I don't have a good catchy word yet for it, but I'll call it the religious mission exception now. But it's not necessary. And non-church religious organizations have successfully asserted the religious mission exception in cases in the past. So I think that I would not be concerned specifically that not having church status would make it hard to assert, or even more difficult to assert at this point, a religious mission exception. But I nevertheless would, as our presentation highlighted, really encourage you to be, any organization, to be affirmative and proactive in defining who it is as a faith community and the standards for its employees. I mean, everything that was in the slides. I think those are the things that you need to do for sure. That would be very helpful. Good tools for litigators like Bill to work with once he gets called in, and many organizations have been able also to become churches, at least in terms of the IRS classification of churches under the tax code, and that's something you might also consider doing.
Great. Well, let's sneak in one more question, and it's also a sticky one, I think, but worth the discussion. So the questioner just asked, what about their personal life and what they do on social media? So how does that play into this conversation as well when you have, I'm assuming, employees in this case, and there's some personal behavior or things outside of work like social media?
Right. I'm going to turn that one to Bill. It's too hard for me.
Well, that's kind of the whole point of what we're talking about in the cases that we've been talking about. And Bostock certainly arose in that situation. Think of he was playing in a softball league outside of work, right? And similarly for messages that get sent. But the bottom line is that religious organizations ought to give some thought to the extent to which they think that professional lives can be separated from personal lives. And they ought to have a community policy that talks about how the individuals ought, in both their professional and personal lives, to be examples of the kind of conduct and belief and that we expect of members of that religious community, and that extends outside of the realm of what they do in the office. Now, these kinds of cases do bring up often in most states issues other than just Title VII or ADA or age discrimination. Many states have a separate statute that prohibits discrimination against persons because of their legal off-duty activities. And so you might end up litigating the issue in a slightly different way in the state court over an issue related to that particular statute. But the defense is going to be the same. The defense is going to be, well, we are a religious organization. We are in the mission of developing a Christian culture and a Christian faith-based community, and we expect everyone to be examples of the kind of life we intend to lead, and to the extent that their conduct falls below that, we have policies for reconciliation, and we have policies for addressing those issues, and then we apply those policies consistently.
Well, no, that's actually a great place to kind of put our pin down there. I know we're coming to the end of our time, but Bill and Stu, you all did a great job, and we didn't even stump you with any of those questions. So we'll go ahead and, since we're running short on time, we'll go ahead and wrap up with a few important announcements here. The first one being, what is the financial outlook of ECFA's members and friends towards giving during this time? Well, I'm glad you asked. Our latest research report, Optimism, yet again, by Dr. Warren Bird of ECFA, tracks various levels of optimism and seeks to explain why, from responses of over 1,500 church and ministry leaders who participated in our survey. You can download your free copy at the link on your screen. And also, speaking of helpful data and benchmarks, you can mark your calendars for ECFA's 11th annual State of Giving webinar that's coming up on November 19th, and Dr. Warren Bird will be joining me for that webinar as well. And then finally, while I have the opportunity, I also want to say a very sincere thank you to our now 2,493 ECFA members, many of whom are represented on today's webinar. We are honored to serve you each day as you model financial integrity and accountability during these times. And also, for other friends who are with us today, now is a great time to take the next step in becoming ECFA accredited. In these days of financial challenge and uncertainty, we know that givers are looking for ministries of the highest integrity that they can trust to steward their resources and see the kingdom advance. To learn more about next steps and a waiver of the $500 application fee to get started, you can email me directly at president@ecfa.org. Well, that brings us to the end of today's ECFA webinar. We hope this has been meaningful to you. You'll be receiving another email shortly with a copy of today's slides and also a link to the recording and other related materials. Well, again, I'd like to thank Stu and Bill for their great presentation and insights, and for each person who joined us today for this webinar. May God bless you as you continue to shine bright the light of Jesus Christ in these times.